Before we begin, we'd like to give special thanks to all of our sponsors for helping make this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 5 consecutive years. And thank you to our platinum sponsors, AuraSure Technologies, Psychmedics, Samba Safety, UKG, and Quest Diagnostics. Thank you so much for joining us for this session with the ATA for a safety regulatory update. Today, we're joined by Dan Horvath, Vice President of Safety Policy at the American Trucking Associations, or the ATA. Dan, how are you doing today?
I'm doing great. Glad to be back. Good to see you all.
Yeah, we appreciate you taking the time to return for our 5th day with DISA. Before we jump into the presentation, I want to remind everyone that if they have any questions, use the Q&A button at the bottom right of the player. Any questions that we're unable to answer today, we'll reach back out to you after Day with DISA. We'll get with Dan, get the answers, and get them back out to everyone. Additionally, we'll make a copy of the presentation available for download in the Materials tab after the session. With that being said, Dan, the floor is yours.
Thank you. Looking forward to being back. Thanks again for having me. I think 5 years now, as you said, this has been going on. So lots of change in that time frame, but I'm thrilled to be back to give you this regulatory update. For those of you that don't know me, that haven't listened to this before, my name's Dan Horvath. I'm the VP of Safety Policy at ATA. The picture is I need to get an update because I don't even look like that anymore. But we'll, I'll get my folks to update that at some point, or maybe I'll go with the younger look there. I don't know. We'll figure that out afterwards. But I've been with ATA about 5 years now, and I handle all of our regulatory policy matters related to safety. So everything from a driver perspective, the vehicle technologies, to qualifications. So primarily we're dealing with Federal Motor Carrier and NHTSA and other highway agencies, as well as Capitol Hill and committees and conferences within those agencies. So been with ATA 5 years. Part of that, worked in the carrier world as a safety director. Got my CDL, I've had that, still maintain that. And before all of that, spent some time as an auditor for DOT. So a little bit of perspective from the enforcement side, working with motor carriers, and now on the advocacy side. So, as I say, anytime I do one of these presentations, one of my goals when we're talking about this information is to provide you with updates about what we're expecting, what we're seeing from FMCSA. But not only that, it really to kind of dive into some things we might see coming down the pike into the future, and then to give you ATA's perspective on a lot of this. So I preface that by saying I try to do my best to say, okay, here's ATA's position on a particular subject, and here's why we've had that position. Recognizing that you may not all agree with me, and that's perfectly fine, but at least give you that perspective of what we're dealing with. So with that, kind of looking at updates we've been dealing with here in 2022 and now into 2023, hours of service, there's not a ton going on, which I think is good news. I mean, for the better part of 2018, 19, and even throughout the onset of COVID, we were dealing with hours of service rule changes. And for the most part, that is finalized and hopefully done with for the time being. I get asked the question all the time as far as, what will there continuing to be changes or not? But what we are seeing some changes are on the ELD side. And I did want to highlight this for you. For anybody that's running into Canada, our neighbors to the north, they now have an ELD rule in place, electronic logging device rule. The enforcement began January of this year, so very recently. It was actually effective last year, but what Canada did is they delayed the enforcement of it just because they realized that not everybody was ready to go as far as being compliant with the Canadian standards. And on those standards, the ELD rule in Canada is very, very similar to what we have here in the United States with one major exception. So here in the States, if you're an ELD provider, you go through a self-certification process. In Canada, if you want to be listed by the Canadian regs, you have to go through a third-party certification process. And that's ultimately what led to somewhat of a delay here with having this rule into place. And I just checked this here a few days ago, as of the beginning of January, there were 74 approved ELD vendors on the list. So that essentially means that if you operate into Canada, you have to utilize an ELD that's approved by the Canadian specs. Our biggest advice to any of the carriers that ask us about this, we say, hey, listen, talk to your ELD provider. If you are going into Canada, make sure they're aware of the regs, make sure they're certified, because you don't want to be placed out of service when you cross the border into the north. On ELD, there are some compliance updates I did want to cover before I shift gears out of here. I believe I mentioned this when we chatted in 2022. If not, I'll give you a quick background on this. There lies the problem of 3G cell towers and the cellular communication providers, the AT&Ts, the Sprint, the T-Mobiles, Verizon, doing away with 3G cell towers because they're all upgrading to better advanced services such as 5G. That makes sense. You might ask the question, why am I talking about 3G cell towers? Well, this matters to you all if you have an ELD device that relies on 3G capabilities to transmit at a roadside inspection. And that's going to matter when you're stopped and you're asked to transfer the logs. And if there's no more 3G cell towers, your device isn't going to work. And in some cases, you're not going to know that this is the case until you actually go through a transfer to roadside. So this began in early 2022. The latest of the sunsets began December of this past year with Verizon. And this will continue. So for instance, you see there in that chart, Verizon 3G, December 31st. That doesn't mean that come December 31st, every single 3G cell tower for Verizon goes away. It just means they're starting the process. So this process will continue into 2023. And just like the Canadian standards for ELDs, what we're telling our folks are, make sure you check with whoever your ELD provider is, make sure they're, number one, aware of it. And number two, that, if it does impact you, what's the plan to address it? Because again, this will be a situation where if you are stopped, and your ELD does not transfer roadside, the logs at a roadside inspection, you're going to be placed out of service. So again, just double check with whoever your customer service agents are for the ELD provider that you use. And on that note, that kind of, is a summary of some hours of service stuff we're dealing with. Happy to take any questions towards the end if you have additional questions on that. So shifting gears, some compliance, safety, accountability, CSA updates. Folks are asking all the time, where are we at with CSA? We've had CSA since 2010. There was a lot of kerfuffle, if you will, for lack of a better word, in the early 2014 timeframe and before about its effectiveness. There were mandated government studies that took place, but we still have the same CSA that we've had in 2010 with one big difference, that now the CSA scores are no longer in public view. So the latest updates we have on that, as far as the methodology goes, is that the proposal to change that methodology will likely come in the near future. And what I mean by this is our indication from our friends at FMCSA is that the revisions are done, the rule is written, the revisions, the Federal Register notice is done. It's just a matter of making it public and putting it out there for notice and comment. So that's the good news side of it. And that's been ATA's stance from the start, is that, listen, we're going to withhold judgment or reserve kind of approval of any of the methodology changes until we can actually read what they are. And the good news is that once FMCSA makes this public, it'll allow for stakeholder comments to be processed as part of the rulemaking procedure. You may recall we talked about this thing called IRT, that's called the item response theory. That was at one point in time kind of the front runner for what the new methodology would be. That's unlikely at this stage, just because IRT is really, really complex. It takes folks a lot smarter than I am, which isn't saying much, to be able to explain what IRT is. It's very technical. And if you can't explain to a motor carrier or a driver, or even a member of Congress for that matter, why a trucking company or a bus company has a score based on X factor, that's a difficult, kind of methodology to support. So FMCSA is likely to look at different methodology. The good news on CSA as well is we now have a pretty robust crash preventability determination program that essentially allows carriers to challenge crashes that have happened, that they've been involved in, but that they think that are, they're not preventable. We all know the biggest frustration with CSA since 2010 was that if you have a DOT recordable crash, it goes on your profile no matter what. This now allows you to challenge certain types of crashes, not all of them, just crashes that are listed in the crash eligibility criteria, and allows for a review of those crashes. The bad news side of things is this has become so popular that FMCSA is struggling a little bit to stay up, to catch up with the number of reviews. We are hearing some cases of 90-day turnaround time, and not to point fingers at FMCSA, but they're aware of it. They know that they've addressed, or they are addressing that. They plan on adding full-time positions. They plan on trying to automate some parts of it. And then eventually looking at the crash types that are eligible for expansion, or rather a review, and expanding those crash types. This is a very human hand, heavy process, to where it does take a human being to review each part of each crash that's submitted. So you can only automate some parts of it, but the good news is FMCSA is working to address that. I think I gave some statistics last year when we went through this, but this is as of the end of September as far as how many crashes have been submitted to the program. You see the numbers there on your screen. 35,528 were submitted to the program that were determined to be eligible. And by eligible, that means that they were eligible for review for preventability. Just over 9,000 were not eligible. But out of all of that, 21,868 were reviewed, determined to be not preventable, 409 preventable, and then 496 were undecided. Undecided could be, various factors where the evidence just wasn't strong enough to prove that it was preventable, but it also didn't prove that it was non-preventable. So they go with the undecided factor there. But when you look at those numbers, it really points to our industry that a majority of CMV involved crashes are not the fault of the CMV operator, as evident by there. No surprise there at the bottom of your screen, when the CMV was struck in the rear, was the most frequent crash type at 11,000, almost 12,000 for those. If there's any piece of advice I can give you with the crash preventability determination program, it's that when you go to submit a crash, please make sure that, number one, it was in fact preventable, that it meets all of the criteria that's listed there. But two, make sure that there's nothing else that existed at the time of the crash that may be looked upon as preventable. And I give the story all the time of a driver that was hit head on by a drunk driver. Clearly, the drunk driver was going the wrong way on a freeway. Clearly, the driver didn't do anything wrong. The carrier submitted this crash for review. It was reviewed and it was determined to be preventable. Now, you might ask, how's that possible? The issue was the driver had a suspended license. The CMV driver had a suspended license at the time. And in the eyes of legal and everybody else, and as well as FMCSA, they're going to look at it as that driver should have never been there in the first place. The crash wouldn't have happened. So I say that as an example of making sure that everything is up to snuff, if you will, before submitting a crash for review. Same thing with vehicle violations, just to make sure there's no out of service violations that would have existed prior to the crash. Certainly if there's vehicle damage after the fact, that doesn't count. But if it's, if the vehicle wasn't inspected or had an OOS violation prior, that's going to be, held against you when reviewed. So getting into the fun drug and alcohol stuff, which I think there's a lot of relevance for what we're talking about today, I did want to go through a couple proposals and updates that we're seeing, give my update on hair testing, which we talk about every time. But before we get into that, there are some pending rules that are out there currently that were introduced last year that I did want to give everybody a brief update on. And the first comes from the Department of Health and Human Services, HHS. So a very quick kind of regulatory, history lesson here. DOT, which obviously regulates the truck and bus industry, they adopt drug and alcohol testing rules essentially as they're written from the Department of Health and Human Services. So for instance, oral fluids, which we'll talk about here in a second, Health and Human Services, HHS, they had to write the guidelines for oral fluid use first before DOT could take up a rulemaking to introduce those into the regs. So therefore, HHS can propose changes to the existing regs, which they are doing. In April of last year, they put a proposal out there, and there were three main points that I'll highlight for you today. And there are really three main points that we had a little bit of heartburn with that we provided comments on. The first was what HHS proposed was they wanted to eliminate what's called the notice and comment procedures when changing the guidelines, such as modifying the drug test panel. And you heard me mention earlier about CSA, when FMCSA publishes proposed changes to CSA, they'll put it in the Federal Register. It'll usually be a 30 or 60-day comment period, which folks can weigh in, and then from there, they'll finalize the rule. HHS is actually proposing to eliminate that public comment period, which is really concerning for us. We like to think and trust that our friends in federal government do what's best for industry, but sometimes, and to their defense, they haven't thought of all the different ways that a rule change will impact industry. And this is one that's really concerning to us, that they could essentially just publish a rule change and it would be final based on an effective date. And we know in reality, with everything we're doing, especially with drug and alcohol testing, it takes time to make changes within your processes. So we provided comments to this rule that said, we're not against change, but we still think you should have to go through the standard notice and comment period in order to do so. The second bullet point there that I'd say is probably a little bit more of a concern is that HHS is proposing a modification to what is considered a refusal to test with regards to pre-employment testing. So essentially, you all know today that if you have a driver comes in and you schedule a pre-employment drug test, but the driver never goes, they get another job, which happens quite frequently, often in the trucking industry, and I think it happens to some extent in the bus industry. That's not a refusal to test. It's just the driver never went. It's a different story. If that happens in a random, it's a refusal to test because random testing is different. What HHS wants to do is they want to modify that definition for pre-employment testing to essentially say that if the applicant has been offered conditional employment but does not report for that test, it would be considered a refusal. And our early estimates of this is this would significantly increase the number of pre-employment drug test refusals. So we'll talk about the Clearinghouse in a little bit. I mean, this is going to exacerbate those numbers within the Clearinghouse. So we provide a comment, kind of giving examples of how recruiting and hiring works within the industry. There's no discussion about if the driver goes in for the test, then leaves the clinic. That's a different story. But if you're just merely scheduling the test and they don't show up, that, in our opinion, should not be considered a refusal. And then last but not least, there were a bunch of technical changes that would impact labs, MROs, and folks that are working in that space that we provided some comments on. So we did send the comments through. They were due June 6th. We opposed those changes. At this point, this is all pending, so we'll wait to see if HHS does anything with this. On oral fluids testing, I mentioned we did have a bit of good news in the beginning part of 2022. FMCSA finally published a notice of proposed rulemaking, which would essentially allow oral fluids as an alternative to urinalysis for DOT purposes. That comment period closed the end of April. DOT proposed to align with the HHS standards. But what they did ask as part of the rulemaking was what testing situations would be best for oral fluids. And ATA weighed in that, we previously supported oral fluids testing only for cases such as post-accident reasonable suspicion. But we had a lot of good data from labs that supported oral fluids testing in all situations. So pre-employment, post-accident, random, et cetera, anything that's covered in the DOT regs. The one, kind of thing that really led that charge was in the non-regulated community, the number of positive oral fluids tests was significantly higher than when compared to urinalysis. And we think that's really due to one major contributing factor, and that's every oral fluids test is essentially an observed collection. Where in the urinalysis side of things for DOT purposes, you only have to do an observed collection, typically if the donor has done something wrong in a process or if it's return to duty testing situations. But a pre-employment test is easy to beat, especially if you know that, hey, I'm going to get tested. You can, as they call it, study for the test, and I'm not going to go into the details there. Use your imagination, but we really think that the benefit of oral fluid testing is outweighs any of the concerns. So it'll be interesting to see how DOT develops that rule going forward. But ultimately, we think it's going to make it a lot easier on you as the motor carrier to do these tests in-house, where urinalysis, oftentimes you're sending that driver out to a collection facility. Oral fluid is a lot less intrusive, a lot easier to do on site, might make your random drug testing process all the more easier with that. On hair testing, this seems to be a regular yearly update that we're not getting any further. Maybe if I'm invited back next year, we'll have some better news, but we still can continue the advocacy charge with regards to hair testing. And just to refresh everybody's memory, ATA supports hair testing as an alternative to the urinalysis process. So we don't look at it as a way to replace urinalysis, but allow carriers the option to use hair testing. The last bit of movement on this was back in 2020 when Health and Human Services proposed a rule. We raised concerns with their proposal. The primary concern being that HHS said that if you utilize hair testing and the hair test is positive, you would have to do a secondary urinalysis or oral fluids test. And from everything we know about oral fluids and urinalysis, when you compare that to hair testing, you're going to have situations where the hair test was positive, the urinalysis was negative, and you would be required to report out that negative urinalysis. So it really defeats the purpose of hair testing to begin with. And then there were other issues, which they put in there that you can only use hair from your head for testing purposes, no facial or body hair, and just a lot of technicalities that we don't think HHS did maybe as good of a job that they should have in that initial reiteration of the proposal. And we're going to propose that going forward, and we did so in our comments. The Drug Testing Advisory Board met in June of this past year to talk about it. We may see final guidelines this year. I'm hearing some rumors of a summer publication. It is on DOT's agenda currently, scheduled for, I think it was scheduled actually for last December, if I'm not mistaken. I had the slide here at the end, but we still don't have a final rule. DOT can't do anything with it until we get to that point. So we think this is going to be a significant benefit to the industry, and it helped to get controlled substance users off the road and add to highway safety. Drug and alcohol testing. I think you have an update from FMCSA through some part of the Day with DISA program, but just to give you kind of a quick overview of what we're seeing, these numbers were current as of the beginning of December. There's usually about a month lag before FMCSA publishes it, but 177,000 plus drug violations in the Drug and Alcohol Clearinghouse, 4,056 alcohol violations. No surprise there, a chart on the right-hand side of your screen, marijuana being the leading drug type, cocaine second, methamphetamine number 3. So those numbers continue to climb. What ATA is really focused on are the return to duty numbers. You are considered not prohibited once you complete the return to duty test. But if you look at those numbers there, 89,000, almost 90,000 have not even started the return to duty process. And that's troubling to us. That's 89,000 drivers. When we talk about driver shortages, ATA estimates are around 80,000. That's that could solve our driver shortage there. But where are these drivers going? Are they leaving the industry altogether? Are they going to somebody who's not complying with the drug and alcohol testing rules? So we're really scratching our heads looking at that to figure out what's happening with a lot of those drivers. The numbers in green there at the bottom of the chart, 44,000 have completed the return to duty process and are eligible to return back to work, with 37,406 actually testing negative during the return to duty test. So in an ideal world, we would see less violations and more drivers returning back to duty afterwards. There are some forthcoming changes to the Drug and Alcohol Clearinghouse, and I think are good news. One of these that just became effective here a few days ago, January 6th, essentially marked the 3-year anniversary of the Drug and Alcohol Clearinghouse. And why that matters is that as of January 6th, when you hire a driver and you're performing your pre-employment verification requirements, you can use the clearinghouse for your sole source of drug and alcohol history, because we now have 3 years of history into that system. So I think this is a pretty significant step. Prior to this, you also had to send paper copies out of the verification. Now, for drug and alcohol testing purposes, you can obtain that request in the clearinghouse, solely within the clearinghouse. It is important to know that you still have to obtain consent from the driver, and there are also pre-employment investigation requirements that are outside of the Drug and Alcohol Clearinghouse that are still required to be obtained, such as accident and safety performance history. And then finally, and this is pretty rare, but I do want to flag it, if a driver worked for a different DOT agency, that information is not going to be in the clearinghouse. So say they work for pipelines or even FAA, and you need to get this information. That won't be in the clearinghouse because this is specific to CDL drivers. So you would have to send a separate verification request there. And then this is an update that we're eagerly awaiting from FMCSA that I think is going to be fantastic. It's something ATA asked for early on when we were talking about the clearinghouse, but essentially FMCSA is planning to unveil a push notification process related to the clearinghouse. And what that process would entail is the Drug and Alcohol Clearinghouse would push a notification to an employer after new information is recorded in the clearinghouse for anybody they've performed a query on in the past 12 months. So say I hire a driver today, and then a couple months from now in April, that driver decides the grass is greener, he's going to go apply for a job somewhere else. While applying for that job, the driver fails the pre-employment drug test. I otherwise would not know about that failure until I run my annual query. And what happens is the driver, comes back to work for me, doesn't say anything about it conveniently, and I don't find out that driver has a violation until 12 months has gone by and I perform a query. This now, once this goes into place, would give me an automatic notification, and then I can take action to remove that driver from duty. So I think very, very good news with regards to that. No official implementation date, though FMCSA has indicated to us that they're hoping for early 2023. If I'm a betting man, I'm going to bet first quarter of 2023 we may see this. So great news on that. And then the last update related to the Drug and Alcohol Clearinghouse is this was a rule that was finalized in 2021, but the compliance date is not until November of 2024. And essentially this means that anytime a driver goes into the state driver's license agency, that's the SDLA, that SDLA is going to query the clearinghouse to see if there's any history on that driver in the system. So if you go in to renew or upgrade or do anything on your license, they're going to perform a search and to make sure there's no history in the clearinghouse. And if there is a history, they're going to receive a push notification, automatically start a downgrade process within 60 days. So good news, kind of closing, we call it the Swiss cheese model, where you have tons of holes. So they're working on closing those holes and making sure the process is even better. And then last but not least, on the drug and alcohol side, we do have a pending advance notice of proposed rulemaking that was published in August of this past year that would look to make everything within Part 40 electronic. So those in the trucking and bus world, you know, all of our regs are in 382. This would also, or excuse me, drug and alcohol testing regs are in 382, but then you have your Part 40 regs as well. This would go through Part 40, and anything that requires, you know, ink signatures, paper format, this would allow for electronic format and storage of those records. So this being an ANPRM, it's a little ways off from becoming a reality. The NPRM is scheduled for August of this year. So hopefully we see that and we can move forward with the next phase of the rulemaking process. And just very briefly, advance notice proposed rulemakings mean it's a little bit more of a detailed rule. So they start with an ANPRM. Next step is an NPRM, and then after that is typically a final rule. All right, so some medical qualification updates. I just had one I did want to pass along to you all that is of importance, and this deals with sleep apnea testing, which has always been something we've been talking about in the commercial motor vehicle world. This goes back to August of last year, where FMCSA published a notice of proposed regulatory guidance. And essentially what that guidance is what they call their medical examiner's handbook. And this is a handbook that the medical examiners can utilize when they're performing DOT physical exams, medical exams on commercial drivers. What FMCSA did in that handbook was they provided updates to various sections. What we weighed in specifically was with regards to the sleep apnea section. So we didn't comment on anything else. We chose just to stick to the sleep apnea section and talk about the proposed changes there. We were a little bit concerned with some of the changes FMCSA put into place, primarily FMCSA, and you know, we understand their attempt here. They're really trying to help medical examiners. Unfortunately, we think it just paves the way for too much disparity out there with regards to sleep apnea testing. They listed, you know, a bunch of, essentially they start out by saying, there is no rule that you send a driver for a sleep apnea test. However, if the driver, you know, exhibits any of these factors, these risk factors, then you may want to, or you can. And we have a lot of problems with the mays and the cans. And this goes back to, you know, legislative mandate that if FMCSA does anything with sleep apnea testing, it needs to be done through a rulemaking process and not guidance. You know, guidance doesn't have the full force and effect of a law, which is a regulation. So we've encouraged FMCSA that, you know, essentially have said, if you're going to do something about this, you need to do it through the rulemaking process. All right, a couple of other updates here with regards to entry-level drivers. We are now, you know, well into the entry-level driver training requirements. They went into effect February of last year. If this does apply to you, this is, you know, some valuable information that you can seek out on the training provider registry website. The link is there on the screen, and you'll get a copy of these slides, this presentation, so you'll have that information. But the good news is, as of the beginning of this year, we now have 4,560 in-person training locations across the country, 608 online, and 444 traveling providers, which I think helps alleviate some concern that there just weren't going to be enough training providers in the hopper to handle the workload of entry-level driver training. One key point I mention all the time that has unfortunately led to some legislative attempts to repeal entry-level driver training is that if you do in-house training, so say you own a trucking or a bus company or whatever the case may be, and you want to bring your own drivers in and train those drivers to get a CDL, you can continue to do that. You just have to go through the process of registering as a training provider. You can register as a private training provider, which means you're only going to do training for your own candidates. Nothing changes there. There's no cost associated with this. We saw a ton of bad information out there, particularly on the University of Facebook, which seems to be the source of choice for some in getting the bad information. But you know, it's just changed the training standard, created a standard curriculum for what an individual needs to go through when they're getting their CDL for the first time. Related to that, we had a pretty big win back in 2021 when the Infrastructure Investment and Jobs Act, IIJA, was signed into law, which created a pilot program for younger drivers. So it's officially called the Safe Driver Apprenticeship Pilot Program, which was modeled after Drive Safe Act legislation. The program officially opened in July of 2022. And what this does in a nutshell is allows an 18 to 21-year-old to operate in interstate commerce under certain benchmark provisions with a trainer with technology requirements. There's 2 different probationary periods, each of which adds up to 400 hours of training. The first, period is 120 with benchmarks that must be passed as part of that. The second period, it's 280 hours that has benchmarks as well. And then the experienced driver, this is essentially your trainer, has to have certain requirements as well. They have to be 26-year-old, have held a CDL for the preceding 2 years, no preventable DOT recordable accidents, moving violations in the previous 2 years, and then 5 years total CMV driving experience. On the truck that the apprentice is actually going to be operating, there's technology requirements that are included. Automatic emergency braking, automatic manual transmission, active braking, active collision mitigation systems, forward and inward facing video cameras. We're in the process of, providing feedback to DOT on the inward piece. There's been some privacy concerns raised with that. Not to mention it was added to the last minute, which we're not too thrilled with because it did knock some carriers out of it. But we're working through that. And then speed limiter is set at 65. You also have to be registered with a DOL approved, a registered apprenticeship program, which ATA does have in place and can assist anybody that's looking to do that. So we think this is a good step in getting the data that an 18 to 21-year-old is capable of operating a CMV safely. You've heard it from me before. I'll say it again. In 48 states in the District of Columbia, you can get your CDL under age 21, in some states as early as 18, and operate within that state. You just can't drive without the state, which to us makes really no difference as far as it goes. Take Pennsylvania, for instance. You can drive from Pittsburgh to Philadelphia, 400 some miles one way, but you can't drive 30 miles west of Ohio until you're 21. So we think this is a good step in getting that data into lawmakers' hands and advocate for changes to the existing regulations. So before I get to some future regulatory items that we may see, I did want to give a quick technology update of some tech items that we're dealing with. The first is a pretty big one that I think a lot of folks care about. Speed limiters. There was an advance notice of supplemental proposed rulemaking issued by FMCSA back in May of last year. And essentially, that's a lot of words just to say that FMCSA is planning on creating a speed limiter regulation. The first step in this process was asking a lot of technical questions related to the engine control unit, who has speed limiters, what is it set at. The comment period on that closed July 18th, and they received nearly 16,000 comments into the docket, which is really high. A lot of those comments, no surprise, were opposed to speed limiters. A lot of them were filed by individual drivers and less so some companies. And there were a lot of good questions that were raised. As far as ATA's perspective on this, we weighed in with what ATA has policy supporting speed limiters set at 70 miles per hour if you have certain safety technologies installed on your vehicle. But we also went on to say, hey, listen, that if you're going to address this, you need to look at things like speed differentials. I hear all the time about speed differentials having an impact on highway safety. And it's important for FMCSA to address those concerns if there's going to be any meaningful action on speed limiters. So the next step of this process is a tentative supplemental notice of proposed rulemaking, which is now scheduled for June of next year. That is an incredibly fluid date. Frankly, I'm a little, pessimistic on whether it'll actually be June of this year. It could be later. could be earlier. And frankly, FMCSA still has the ability to say, we're going to withdraw this rulemaking and not move forward with it. Related, and I know I talked about ELDs in the context of hours of service at the start of this presentation, but I do want to talk from the technical standpoint of FMCSA is looking at the technical specifications related to electronic logging devices. Now that we've had ELDs in place for some time, they published an ANPRM back in September that looked at different aspects of the ELD rule, whether they should apply to vehicles prior to 2000. What do you do when you have an ELD malfunction? What do you do when you need to remove an ELD from the approved list? The technical specifications, such as when and how they record certain data parameters, and then the certification process. And we work with our members to identify common concerns and provide that information over to FMCSA, which was due the beginning or the middle of November. And on this one, we're looking at a tentative notice of proposed rulemaking date of November of this year. So that would be almost a year after the first step of that rulemaking process. And then two more tech updates here. One is unique electronic identification of CMVs. This was a rulemaking that happened in September of last year. FMCSA published this in response to a petition from CVSA. And without going through this point by point, essentially what this would do is create an electronic identification system so that law enforcement could obtain information from your vehicle without necessarily having to pull you over. So it would be something to the extent of they hit a button, you get an alert in your truck or your bus, you have to hit a button to approve it, and it sends that vehicle identification number to law enforcement without needing to stop the vehicle. So there's pros and cons to this. The pros could be that you may have to stop for less roadside inspections. The cons being there's a lot of data and privacy concerns with this. What information would FMCSA be obtaining from you, and how's that going to play into your operations and what you're doing on a regular basis? So this was a pretty, I don't want to say contentious, but there was some pretty spirited discussions with this that we wanted to make sure that we weighed in with our proposals on it. 1,300 comments, which is again pretty high with the process looking at it. And some of these comment periods will only get 30 comments or so. So when you're seeing 1,000 plus, that shows you, I think folks really care about it. And I think it's a good, kind of a good step that folks are taking the opportunity to weigh in on something and just not saying, hey, let the feds figure it out themselves. So I really do encourage you, anytime you care about something, file comments. You don't have to be an essay writer. You can go in and do it, and those comments can speak a lot of volume. And last but not least, some underride provisions that were required as part of the Infrastructure Investment and Jobs Act. You've heard me talk about this before. This would have mandated side and front underride guards on vehicles. Instead, what IIJA did was several provisions that look at research standards, adding the rear underride guard to the annual inspection criteria. And what this chart shows you, the X marks that action has been taken on it already. And then the 3 at the bottom of the list are items that need to be done that have not been dealt with by FMCSA yet. All right, this is the beauty of electronic. I can't see if you're sleeping or not yet. So a couple more updates here, and then we'll kind of wrap things up. One hazardous material item I did want to get out to you all, for those of you that are engaged in the transportation of hazardous materials. PHMSA, who writes the regulations for hazmat, is looking at electronic hazardous communications. And what we are most interested in, ATA working with National Tank Truck, is shipping papers. So currently, if you operate a vehicle that has hazardous material, you have to have a paper copy of your shipping paper in hand. It can't be electronic. And in this day and age, we really think that electronic should be the format and the way to go. So we weighed in, that our comments of why we think this is the case. They were due the end of October. This will be a little bit till PHMSA develops this rule, but we see that they're at least receptive to wanting the information to move forward with it. So, one thing I always do as we, kind of wrap up these presentations is to give you what I think we may see coming down the pike into the future. And being that we're fresh into 2023, this is a great time to kind of go through just that. So what DOT publishes typically 2 times a year, and they just updated this last week, even though it's labeled fall of last year, that's what they're calling it, but it was just published last week. This is called the DOT agency rule list. And I like to think of it as this is DOT's kind of wish list of regulatory items that they want to accomplish going forward. The ones, there's 3 on there that are highlighted in a different color. That means they've already taken some action on that. But the rest listed there on your screen, this means that these are items that they'd like to accomplish. So for instance, safety fitness procedures. This would look at the rating system of motor carriers and how a carrier is given a safety rating, redefining that whole process. Looking at CDL testing flexibility. How do we, get drivers into the industry more expeditiously without sacrificing safety? Automated driving systems. We're likely going to see a rulemaking in the very near future that addresses automated vehicles, vehicles that do not have a driver in place. Automatic emergency braking, drug and alcohol clearinghouse provisions. That's proposing revisions to the drug and alcohol clearinghouse that mainly deal, from my understanding, with back office type implications and running queries and so on and so forth. Speed limiters was on the list. I covered that. Looking at emergency exemptions and what an emergency exemption does and how it clarifies, or rather impacts, the industry. Definition of a tank vehicle. And then on the other side, DOT OST, that's the Office of Secretary of Transportation, 2 drug and alcohol pieces. The first being DOT's wanting to create an appeals process for an employer decided drug and alcohol testing refusal. So essentially, if your employer says you refuse a drug test, you as the individual would have the opportunity to go in and challenge that. And as I mentioned previously, looking at electronic signatures and forms and making those electronic and allowable in Part 40. And then an AEB mandate on the NHTSA side. So on the automatic emergency braking, just a note there that FMCSA and NHTSA would both have to write a rule for that. It would need to be kind of a joint rulemaking. And then last but not least, this is a list of what DOT calls their significant rulemaking. This is, a significant impact. And these are proposed timelines there. Automated driving systems, AEB, safety fitness, heavy vehicle speed limiters, application for employment, and looking at some hours of service implications for agricultural commodities. One thing I do want to leave you with these dates. So for instance, speed limiters, you see a proposed date, June of this year, June 30th. That can mean a whole lot of nothing. These dates are incredibly fluid. They move often. So that just gives you kind of an idea of what the anticipated date is. But just because it's June 30th doesn't mean that we'll see this rule emerge on June 30th. And with that, I think I'll stop talking here. And that's my contact information on the screen. As I say, always always appreciate the opportunity to present at these events, and hopefully you take some away from it. And I know that's a lot, but in the safety world, things are complex. So I like to try to give you all the details as compared to you having to write down word for word. So I do think we have some questions that have probably trickled in. And with that, I'll take a pause and we can turn it over.
Awesome. Thanks so much, Dan. I know we're tight on time, but can we just sneak in 4 or 5 quick questions with you?
Absolutely. Happy to help.
Awesome. So do you think hours of service rules will stay the same in 2023?
It's a good question. I do, simply because last year, and I didn't talk about this specifically, but it was last summer, the court challenges that were out there on the 2020 changes, that was finally settled. The appeals was denied, and which is good news. We thought it should have been denied. So I think we're going to see the same hours of service rules for the time being. If anything, maybe personal conveyance, which is this big contentious topic that'll get discussed. But for the time being, I think we're going to have the hours of service that we have today. Great question.
Awesome. Great. You mentioned sleep apnea. Will FMCSA make any changes to the testing requirements?
I'll tell you, when they do, there's going to be some long days for the ATA team, just because it's a really hard topic, which I truly believe why FMCSA hasn't done anything to date on it. They're mandated by Congress. If they change anything, and it's what kind of I alluded to earlier, they have to do it through a rulemaking process. They can't just put guidance out there and say, here's when you should or should not do, sleep apnea testing. From our perspective, it's much broader than just when you do a test or not. It's when you've identified somebody for sleep apnea, what's acceptable treatment? And then, why are we making folks go in every year to get a new test? Because you're just going to get the same results. So I don't know that it's a priority for FMCSA. So I would put it in the bucket of maybe. It's definitely not one that I'm for sure that they're going to do. It's possible, but I think there's some other things they want to get done in the meantime. That's my off the cuff kind of answer on it.
Gotcha. Well, how about oral fluid testing? When will that be allowed for all testing purposes, or will it be allowed for all testing purposes?
So I know it will be allowed for some testing purposes, which, initially there was only really a good argument for post-accident and reasonable suspicion. But so we know for sure, at least it'll be allowed in some limited cases. The question is, will it be allowed for everything? If and when, I'd say maybe later this year we could see a final rule on that emerge, because we just dealt with it last year. But FMCSA would have to have the data to prove that oral fluids is just as effective in any testing scenario, and there's some compelling data to say that. Gotcha.
What's going to happen with marijuana legalization and the trucking industry? It's a broad question. Yeah, that is. I'll say this. It's not a matter of if, but when marijuana is legal across the entire country. It's happening widespread today. As far as the impacts on trucking, nothing's changed. You're still regulated by DOT. You're still prohibited, for marijuana use. However, President Biden just last year had, kind of tasked his folks to look at the possibility of decriminalization of marijuana, and the kind of pardoning of anybody with a federal offense for marijuana. And while that's fine that we look into it, until we have an effective tool for the detection of marijuana at a roadside inspection that detects a per se impairment like we do for alcohol. Mm-hmm. Our stance is it should stay on the DOT panel. I just think we're ways off from getting there. So our fight at ATA day in and day out is to ensure that whatever rules that are legalization efforts that are happening, that DOT can continue to test for marijuana as long as it's a Schedule I drug. Gotcha. And I want to be respectful of your time. Let's sneak one last question in here. If we were unable to answer your question today, just know that we're going to grab all those questions, get them in front of Dan, get answers for them, and then get them back out to you over the next week or so. Dan, did you say that I still need to perform a previous employer check despite having the past testing already in the clearinghouse? Absolutely. So great question. I'm glad you asked that. And frankly, I think this is going to be one that is missed by carriers. So if you look in the regulations in 391 in your investigation and inquiries, and I don't know the exact site, but our citation code, but drug and alcohol history is just one small part of what you're required to obtain for a previous employer. And that drug and alcohol history is only going to be in the Drug and Alcohol Clearinghouse. And mind you, that's only going to be FMCSA CDL information. So if a driver worked for a PHMSA regulated entity, that's not going to be in the clearinghouse. You would have to do a separate check. Beyond Drug and Alcohol Clearinghouse, you're still required to obtain other safety performance data that's often referred to, such as previous DOT recordable accidents that you're required to obtain. So there is still going to be that separate process. Just because we have the clearinghouse, it doesn't, make it all a one-stop shop. You still have to, unfortunately, do the other processes to comply with the rules in 391. Yeah, no, I think a lot of people are going to be caught off guard. Yeah. I know we proactively reached out to a lot of our customers to tell them exactly that you had to do both, just because one doesn't have enough information to satisfy the requirement. So I'm glad we're talking about that more.
Absolutely.
Well, Dan, thank you so much. Greatly appreciate you spending some of your time with us today and sharing your wisdom and your knowledge. Thank you.
Absolutely. Appreciate you having me, and hopefully it was worthwhile to your group, but always happy to participate. Thank you so much.
Awesome. Thank you so much, everyone, for coming out.